Good day, everyone. Welcome to Legal Corner. We'll be discussing on a topic Nemo that Quod Habet. And before we proceed, we would like to introduce ourselves. We have with me, I'll start with the lady,
My name is Naomi Okpara.
and
My name is Efrego Destiny.
myself is Mosu C. Emmanuel. All right. So we're going to look at, first of all, the meaning of the maxim Nemo that Quod Habet. So I'll start with our lady. What do you understand with regards to this maxim?
The maxim named discourse non habet, like you said, is a legal maxim which is translated to mean a person cannot give what he does not have. This maxim is usually applicable under law of contracts and commercial law, state of goods specifically, where a person cannot validly transfer title of ownership which he does not have.
All right. Mr. Destiny, do you have anything to say about it?
Okay, like my colleague have said,
Yeah.
that this is a generally accepted principle of law. That is to say, the law does not allow anybody, no matter who you are, no matter how high ranked you are in the society, the law will not allow you to give out what you don't have. That is to say, in a contractual situation where two parties agree to sell and the buyer agrees to buy, and the transaction actually come to an end, right? The law is saying that if after this sale the other party does not have property in what he sold, that contract is null and void.
All right. Thank you very much for that insightful one. Now, I still stick with you. In what situation and circumstances can we apply this principle? I think you were already on that earlier.
Yes, the principle, as I've touched before, apply in so many situations. It cut across land law, law of contracts, commercial law, and even down to equity. So it is actually a prevalent principle of law.
All right. Ms. Naomi, do you have anything to add to that?
However, as my colleague have said, the principle specifically in equity touched the doctrine of priority of interest yes, in land and registration of titles of documents. However, it's also touched the principle of transfer of ownership of copyrights. This principle of transfer of ownership of copyrights here specifically means that for a person to validly transfer ownership of copyrights or for ownership of copyright to validly transfer, the person transferring must ensure that he owns the copyrights. According under the copyright law, copyrights can be transferred in Nigeria. Hence, for a person to transfer copyrights, he must ensure that he owns it himself.
All right. Thank you very much for that. I'll still stay with you, Ms. Naomi. We've mentioned several areas of law where we can apply this particular maxim. But now let's narrow it down to the doctrine of priority of interest and of registered title.
Okay, this doctrine of priority of interest of registered title is a doctrine under equity, the doctrine of equity, which, as we all know, common law was harsh, so equity came to mitigate. So this doctrine now applies where there are conflicting interests in land. The general principle in this doctrine is that where there are conflicting interests, the interests rank prima facie order of creation. This is based on the temporal order rule. This doctrine now, in the case of Gege and another, it explains this doctrine and it imputes the doctrine of Nemo that non-habet, how it affect this doctrine. In this case, a property was sold by a buyer. The agreement of property was that the property is supposed to be sold for 1,000 naira. In that year, whether it's 1847, February 1847, under customary transfer of interest. However, the owner, after selling it at that time, we sold it again October that same year under the same interest. The court held that the interest rank prima facie in order of creation, hence the first interest overrides. However, the court went further to say that where there are conflicting interests, the principle of Nemo Quod non Habet applies, because the former cannot sue, the latter cannot sue the former for ownership of the title, cannot challenge ownership of title, because the seller has already exhausted himself of ownership, hence cannot validly transfer ownership to the second party. It also applies to registration of title, yes, where in the case of Ashiru vs. Olokoya, where the court held that where there is registration of titles, the first to be registered supersede the other. However, the court also went further to state that even if there was registration of title, the first buyer, even if he registered later, although he registered later, still has ownership over it, because the seller, having exhausted himself the right of ownership, cannot resell to the second party. Hence, the second party does not own the property per se and cannot challenge the rights of the first buyer. So I think this.
All right, thank you very much, Ms. Naomi. We'll look at the second area of law where this maxim applies, and we're going over to Mr. Desme. What is sir?
Okay, thank you very much, sir. Okay, now the other area this doctrine apply is commercial law. Now, there is a general principle in commercial law which states that one cannot actually sell and give out what he does not have. That is the Nemo Quod non Habet. In fact, this concept of law, this principle of law, to my own conscience, is the most important when it comes to commercial transactions. Section 1 sub 1 of the sales of goods law of Rivers State. Yes, I will have to restrict myself down to the sales of goods laws of Rivers State. Yeah. Now, section 1 sub 1 of the sales of goods law of Rivers State define a contract of sale as a contract whereby a buyer transfers or agrees to transfer property in goods to another person who is the buyer, who has agreed to buy for a consideration which is called the price. Now, looking at this section, you will understand that there is property, that is to say, where there is consideration given and the seller fails to transfer property in this goods, he did not sell anything. Section 11 sub 1 of the sales of goods law of Rivers State also states that in a contract of sales, that the seller, while transferring, that in his agreement of sale, na sale of goods agreement, like agreement of sale, that at the time of sale, he must have property to pass, or in an agreement to sell. When the time will come up for him to sell, he must also have property in that goods to sell. That is to say, if at the time where they agree, the contract has come like have been executed, not executed, at that point where it has been executed, he must actually have property in the goods to sell. Or where there will be an agreement to sell in the future, that is an executory contract. When the time reaches for the thing to actually turn into an executed contract, he must have property in that goods to sell. This general principle has also been recognized in section 20 sub 1 of the sales of goods law, which states that where one sells or is an agent to sell, he must make sure that he has property in the goods. That is to say, if there is no property in the goods in the time he sold, that means that sale will not take place, because the buyer who bought has the same right as the seller. That is to say, since the seller does not have right in the property, the buyer too does not have right in the property. This has also been judicially noticed in the case of Roland and Doval. Now, what happened in this case? the seller sold calf to the buyer, and the buyer used this calf for as long as 7 months. However, using the doctrine of tracing, they discover that this cow was actually sold to this buyer, and then he was arrested and detained. And then he came back after 7 months of selling this goods. He came back and then sued the seller. The court held that when the seller sued, he did not actually have property in this goods, that he cannot sell what he does not have. For that reason, the buyer can actually sue for the price of which he has paid. In Bishopsgate Motor and Transport Brake Limited, Lord Denning established a general principle which states that Nemo that Quod non habet is a principle that cannot be dispatched. It is a principle that is as important as the contract itself. He went further to say that though this general principle is there is also the principle of a bona fide buyer who bought without notice. That is to say, this general principle in commercial law, which is the Nemo that Quod non habet, also has an exception. Now, what are the exceptions to this general principle? Okay, what is exception generally in law? Exception states is like a leeway where one can actually hold hand on and say, okay, though this happened like this, however, if I come from this way, the law is going to protect me. Now, the exceptions to this general principle are many. However, for the purpose of this video, I will just give 3 of these exceptions and also give a detailed explanation of just one. Now, I will give a detailed explanation of 2. Pardon me. The first exception is extropel. The second exception is where one buys the product in market overt. And then the third one, of which I'm going to state today, is where he sold through an agent. Right? Now, the first one is extropel. Looking at section 20 sub 1 of the Sales of Goods Law of Rivers State, there is a clause there which states that although this seller does not have rights in these goods, like he does not have property in these goods, however, while selling, if the owner of the goods acted in a way that shows that he supports the selling, if he had actually made a statement that shows that he supports the selling, this principle is not going to apply. That is because the rules of extropel will hold it that you saw when this guy was selling, you did not say anything. For that reason, you are stopped from saying that this seller does not have property in this goods to transfer to the buyer. The second one is the doctrine of market overt. Now, in Lee and B, the court define market overt to be a market that is generally known in the society and accepted by law. Now, one would ask, what if this market is not recognized by law? Now, in this same case in Lee and B, the court also established a way whereby, though it is not a market recognized by law, but if it is recognized by custom and the people, and it is radically known to be a market where they sell such products, that can be known as a market overt. Now, where one buys in a market that is popularly known, for example, the Ikoko market in Maitre, which is popularly known for selling spare parts, motor spare parts, where one goes to such a place and buys a product that is prevalent in that market, the principle Nemo that Quod non habet will never hold him. That is because he bought bona fide in a market that is prevalent for that. And such market is open, that is to say, you can come in and leave, and everybody know that this market, this is what they sell, right? However, in this general rule, there is also an exception. Where this market is closed, the rule of Nemo that Quod non habet is going to hold the buyer. Also, where this market is although known as market overt, but is not, for example, what you went to buy there is not popularly sold there. For example, let's use the Ikoku market again as example. We all know that it's a spare part market. However, when you go to this Ikoku market to buy bag of rice from the shop of one selling motor parts, Nemo that Quod and Habet is going to apply, because you know that at that particular time and in that market they don't sell such product. So with what I've seen under commercial law, although this is a general principle, where one actually hides under any of the exceptions, the principle of Nemo that Quod non Habet will not apply to him. Thank you.
All right, thank you very much. That was a nice one and detailed as well. All right, before we bid farewell to our listeners and proceed to the next one, we will have to hear your last thoughts, Miss Naomi. Do you have anything to tell our listeners? Maybe something you missed out before earlier, or an advice as regards to the topic?
Okay, under the doctrine of Nemo, Quod, Habet, under the magazine, I think that's magazine 3, that's legal magazine, where equitable magazine, where the magazine states that where there are equal equities, the law prevails. Under this magazine, the second person, I think that should be an exception to that registered title, because where the person has a legal title as opposed to an equitable title, he can prevail over, even if the ownership has been extinguished from the owner, he can prevail over the first buyer. And also where it was carried as bona fide, like my colleague has said, where the such project was carried as bona fide, the second title where it was done bona fide without notice of a superior interest or an existing interest, second title may also override in such cases. I think that's all.
All right, thank you very much. I don't know if you have anything more to say. I know.
Actually, do not have. My colleague has said it all. She has actually buttressed the nice points for us to go with.
All right, thank you very much, dear listeners. Welcome to the Legal Corner Part 1. We'll see you next time. Thank you very much.